Hi, I'm Pattu from freefincal, and in this video, let's take a look at why SEBI imposed rupees 5 lakh fine on ICICI Prudential Asset Management Company and the associated ICICI Pru Trust. So, SEBI had asked an auditing firm to look at the books of the fund house, I think in 2017, and the auditor had come up with three instances where they alleged that the fund house had violated the SEBI norms, SEBI regulations, and SEBI gave the fund house some time to answer these to offer a rebuttal to these allegations, and the fund house did that. And an adjudicating officer was appointed to take care of both the allegations as well as the rebuttal from the fund house, and a decision was made. And out of the three allegations, the officer found that two of them were actually violations and one of them was not, and the total penalty imposed was rupees 5 lakh. So let's take a look at all those three one by one and discuss what they are. The first one is with respect to ICICI Prudential FMCG, Fast Moving Consumer Goods Fund, a thematic or a sectoral fund, if you'd call it. The auditors said that three stocks, La Opala, Tara Jewels, and V-Guard, they were consumer good stocks, but not fast-moving consumer good stocks, and therefore the fund house violated the scheme document, and therefore a penalty should be imposed. However, the fund house said that there's no definition, there's no strict definition of what is a fast-moving good, and they were within their rights to invest in this, as they had actually provided a long explanation of for each of these business and how this can be called as FMCG. But the adjudicating officer said that these stocks were not found in the BSE and the NSE FMCG indices, and ruled that they cannot be called as FMCG stocks, and found that this fund had violated the norms issued in the scheme document, and said that this allegation is actually a violation. I mean, if you discuss about it, I mean, this is a very trivial matter because the whole weight of all these stocks at held at different point of times is less than 3% of the portfolio. I mean, only one stock was more than 1% at some point of time, and that was also lowered off soon. So it is a small problem, and the fund house could have avoided it by wording the scheme document carefully. In fact, this is a trivial matter. There's a bigger problem which SEBI should address, and I've been talking about it for a long time. In the scheme document, they say all sort of things. They give a very broad kind of statements, very general, nothing specific. The investor will gain nothing insightful from the scheme document, but they write all the juicy stuff. The fund will do this, the fund will pick stocks in a certain way, and so on. They do that in the promotional material, and those statements are not found in the scheme document. This is a bigger problem which SEBI should address, and not worry about trivial matters like this, in my opinion. The second allegation is second allegation is due to a bond default, the Jindal Steel and Power Limited bond default. The auditor said that when the bond was close to being junk and actually became junk, the fund house did not sell the bond and rebalance the portfolio in open-ended and closed-ended debt funds that had the bond. But then the AO noted that there was no norm, that there was no ruling or no wording in the open-ended scheme that warranted the fund house to actually sell the bond immediately. Even if they can't sell it, they will have to somehow get rid of it. There was no such wording in the scheme document. And in the closed-ended fund scheme document, there was a wording that said they will try to do it within 20 days, I think, but they will also take risk and reward benefit into analysis into account before selling or whatever, rebalancing, whatever. The AO deemed that they were within their rights to not try and sell the bond and not rebalance the portfolio in the open-ended case, and in the closed-ended case, they took a call. It did not hurt investors in any way. So I think there's no wrongdoing here, and the AO said that the second allegation made by the auditor is not a violation. The third allegation is the biggest problem. I had talked about in a video. I said, can mutual funds fail like a bank? I had talked about how a mutual fund is run like a trust. That is, the sponsor of a mutual fund appoints a trustee. There is an asset management wing. The trustee oversees the operations of the fund and should act on behalf of the investors. Everything that the trustee should do, the trustee does, should be for the benefit of the investors. Now, the auditor found that the trustee had authorized the fund house directly to declare dividends on their own, the quantum of the dividend, the date of the dividend, all the powers were given to the fund house directly. This is a big mistake because it goes against the fiduciary responsibility of the trustee. The trustee should be the one who determines, they should sign off when the dividend can be declared, what is the quantum of dividend, everything for all the funds. They should not be saying that the fund house can take care of this, and the fund house gave a flimsy excuse saying there's not enough time to comply with the SEBI norms of announcing in the newspaper and so on. That's just a nonsense BS kind of excuse. That did not wash with the adjudicating officer, and the adjudicating officer said that this is a violation of SEBI regulations, and therefore, because of the first and the second, that is the first one with where 3 non-FMCG stocks, and this one, because of that, a total of 5 lakh penalty was imposed. This is 5 lakh is really nothing. But the point is that this should not happen again, because in fact it has happened again. ICICI had noted that India Bulls had done this, what the trustee did about asking the fund house to do it, and at that time SEBI did not impose any penalty. ICICI argued that they did not do it then, so we should also not be subject to any penalty. But that the AO did not agree to that. That's a step in the right direction. But the fine should be much higher in this case, because the trustee is acting. I mean, if the trustee does this, then the whole framework of a mutual fund will break down. Everything depends on how the fiduciary responsibilities of the trustee is the basic framework on which a mutual fund is operating. If that goes away, then we will lose complete trust in mutual funds. Therefore, I think head should roll, like the trustee should be changed, or there should be a big change in the framework, tighter regulations, and a stronger penalty should be imposed. So out of all the 3 allegations, the third one is the most serious. I mean, we know it only when it has come out in the open. I mean, I don't know what else is going on in the other fund houses. The more you learn about mutual funds, the more disillusioned you become. Anyway, so that's the reason why the 5 lakh penalty was imposed. Someone had asked me, will it come from the expense ratio? Look, the expense ratio is the bread and butter of the fund house. So everything that the fund house does, whether it pays distributor or pays fund managers or pays these penalty, everything naturally will come from the expense ratio. Will they increase the expense ratio because of just this 5 lakhs? Very unlikely, because this is just not even peanuts for them. So that's what I wanted to say. Catch you later. Bye bye.